Hello and good evening, everyone. Thank you for tuning in to Unpacking Your Inheritance with Sarwa. My name is Eamon Gebre, and for those of you who have had the pleasure of having a conversation with over the last couple of years, thank you so much for joining us today. And for those of you who we haven't had the pleasure of introductions, I am the head of wealth advisory here at Sarwa. I've been with the organization now approaching 2 years, and I've been in financial services for well over 20. I spent much of my time working with organizations such as HSBC, TD Canada Trust, and I even did a brief stint as a debt manager working for a company by the name of ISDM. Today, we're here to discuss something that's very near and dear to many of us. We're talking about inheritance. What are the UAE laws? What does a will allow you to do? What does a wealth beneficiary through Sarwa allow you to do? And many more topics today. I am joined by a host, by my colleague, my co-host, Ms. Tasleem Sayani, who's actually having some technical difficulties trying to get into Zoom at the moment, but she will be joining us very shortly, but I don't want to keep you guys waiting at all. In this webinar today, we are going to be uncovering a lot of misnomers, a lot of assumptions when it comes to UAE inheritance laws. And I want you to feel comfortable to be able to ask the questions, whether you'd like to ask them by name or in an anonymous fashion. Feel free to go ahead and just log in and type it into the Q&A section. We will be addressing them towards the end of the presentation. And I'm joined alongside with Tasleem. Congratulations. Thanks for being able to make it. Oh, may not be able to hear me as yet. I think the audio is still going. That's all right. What we'll do in the meantime is I'll start the presentation just to be able to get the ball rolling all together. As I said, if you have any questions, don't hesitate to type them in right into the Q&A section. We will be addressing them towards the end. Now, about Tasleem. Tasleem, are you able to hear us at this point in time? Oh, we're not able to hear you, Tasleem. No? All righty.
Eamon, are you able to hear me?
Now we can hear you. Amazing. We made it.
We made it.
Look, we go through the same thing, by the way. 2 years in, post-COVID, we're still having challenges with webinars. So we all go through this. So I just thank you so much for joining us. We were just at the point right now where I wanted to introduce you, but I think you can probably do a better job of introducing yourself. So please do let us know about the work that you've been doing and your experience.
Sure. Thank you. Thank you, first of all, Eamon, to you and the team at Sarwa for inviting me. I'm really excited to speak to you guys today. So yeah, basically I'm a solicitor qualified in England and Wales. I'm also a licensed legal consultant here in the UAE. I've been in Dubai since 2008 and basically been advising clients, both Muslim and non-Muslim, expats, non-residents, on this very important area of law, which is basically wills and inheritance. And I tend to advise clients both sort of in relation to local laws and laws which may apply to them, such as common laws. As an English qualified solicitor, I can also advise on English wills and English succession matters as well.
Amazing. Since 2008 is what I heard you said. So, I mean, it's been quite a number of changes, not only on the law perspective, but also just the level of activity and the growth of the country altogether. So I would imagine you've come across a number of different scenarios when it comes to UAE inheritance. Yeah,
absolutely. There's been a hell of a lot of change, especially in terms of the development of the local legislation. It's become a lot more defined. And actually, when I came here in 2008, there was a lot of uncertainty on this subject. But I'm really pleased at the developments that have happened and also the rate of developments. It's changing very quickly and it's moving in very much the right direction and benefiting a lot of people.
Absolutely. I know we're going to be unpacking a lot of this in the presentation itself. So what I'll do is I'm just going to jump in to talk about some aspects of how Sarwa is tackling this topic itself, and then we'll jump right into some prepared questions that clients of ours have asked over the years. And I couldn't think of a better person to address these questions to than yourself. So thank you so much again for being here.
I look forward to it.
Amazing. So let's start with just kind of getting a couple of things out of the way. It's important to highlight that the conversations that we're having today should not be interpreted as one-on-one financial or legal advice. Each and every one of our circumstances are unique, especially when it comes to very sensitive topics such as inheritance. You can't take generalities and apply it to your own specific circumstances. I think it's important to speak to a solicitor who is licensed to be able to talk about this and make the best decision that's made ideal for you. And in addition to that, the discussion that we're going to be having today are based on the present laws that we are working with. Things may change in the future and we will not be able to anticipate them because we cannot predict the future. So take that into consideration with regards to the conversations today. And towards the end of this presentation, you will have the contact details of Taslim. Feel free to reach out to her if you have any queries or if you'd like to delve a little bit more about your personal circumstances and how they would be treated here in the UAE. Now, for clients who've been with us for quite some time, this statement will ring true to them. Our mission at Sarwa since the beginning, and it continues to be till today, is that we want our clients to be financially empowered. Well, what does that mean? Our proposition is very straightforward in the sense that we want to make sure investing is very simple, easy to understand, transparent, and cost-effective. Each and every, I would say, action that we take here goes back to the pillars of making sure that we democratize investing to make it accessible for every single individual. It shouldn't be something that is only made available to a select few. This ethos is actually what gave birth to Sarwa back in 2017. We opened our doors through the DIFC in December of 2017, and that's when Sarwa Invest was born. And for those of in the audience who've been with us since then, you've seen the evolution of Sarwa, where at the time we were working as a broker in which you had a shared relationship between a third-party broker and ourselves, and we were managing that relationship together. Now, one of the key things that we made a focal point for us is that we wanted to listen to our customers. We don't want to make assumptions as far as what they need or what they want. We had a very great feedback loop in which we listened, we tabulated, and we took action based on what our clients have asked us to do. And that's what gave birth to local funding in November 2020. And this was a great, overhaul here, the way that we operated and the way that we managed our clients' assets. In fact, we even upgraded our license to allow us to facilitate local transfer or local funding at no cost to our clients. As time went by, we took more feedback from clients who said, hey, I would like, I like my Sarwa dashboard. I'd like to see it more often, but I'm not always in front of a computer. Do you mind, could you guys consider maybe creating an app? To which we did. And the Sarwa app basically gave birth to the ability to do easy funding, which is a very convenient way to be able to fund your Sarwa account on the go. We started receiving more feedback from our clients saying, look, we want a bit of crypto exposure in a managed portfolio, but we don't exactly know how to approach it. And our banks are not necessarily offering this. So we did the homework, we did the research, we did the analysis, and we came up with solutions that allowed you to incorporate Bitcoin into your Sarwa advisory portfolios. We continue to grow. We continue to mature as an organization. And our clients also matured during that journey as well, because rather than looking at Sarwa as just a proposition for their advisory service, they also asked us to give them solutions for their trading facilities that they have externally. So rather than having a fragmented relationship where you have a broker account here and you have your Sarwa portfolio here, we created Sarwa Trade as a complementary solution to allow clients to invest in markets, in sectors that they feel really passionate about, and they wanted to get a greater exposure to it. Sarwa Trade gave birth to Sarwa Crypto, and more recently, the ability to open multiple accounts at Sarwa. We see today clients who are opening 2-3 accounts for any number of different goals that they may have, whether it be a long-term goal such as retirement, something midterm such as saving up money for their homes. It could even be education savings and actually creating accounts and naming them in the name of their children itself, which is an amazing thing to see. Now, as I said, it's feedback that we've taken to be able to provide these services to our clients. And as we've matured, our clients' circumstances have also changed over the years as well. Back in 2017, the average age of our client was probably in their late 20s, relatively early in their financial careers, relatively early in their employment careers. But as the years went by, they became mothers, they became fathers, they became uncles, aunts. They also became caregivers for parents who have reached that stage of retirement, to which that they're managing money not only for themselves but also in consideration for other people. These clients themselves also referred other clients who were in similar circumstances and life journeys themselves, and the types of requests started to change. started to adjust slightly. Wealth beneficiary has been a very popular request over the last couple of years. And this is an area that we haven't, entered into. It was actually, to be quite frank, it was an area that was relatively new to us and uncharted waters. And in the past, information has been quite opaque when it came to how inheritance laws are applied, whether it be an expat, national, Muslim, non-Muslim. It was an area that our competitors haven't quite cracked and quite really understood and offered it as a solution to their clients. Currently, as we speak right now, your bank accounts themselves, they don't have the ability to nominate a beneficiary. How do real estate assets, how do they apply? These are areas that we weren't very familiar with, but we took it on as a challenge to be able to address and get down to the bottom of it. And it was a journey, and I'll be very honest and open with you guys. It was a journey in which we had to speak to so many different stakeholders because, as I said, information was relatively difficult to be able to glean and be able to understand. We spoke to our regulators, we spoke to the courts, we obtained legal advice. There was a number of different avenues, and we wanted to make sure that all stakeholders are on the same page and that we would be in a position to allow our clients to nominate a beneficiary. Now, what does that look like? Well, we were successful at it. And actually, just quite recently, we launched the ability for clients to nominate a beneficiary for their Sarwa accounts. Through the app itself, and I have a lovely tutorial or video tutorial here that I wanted to show you as far as how it works, because we've done a lot of work to simplify this process. Again, back to the ethos of allowing clients to better understand simple investment solutions, transparent and cost-effective. We launched the wealth beneficiary through the Sarwa app itself. What does it look like? Well, I'm going to play a little video for you. On the bottom here itself, on the Sarwa app, you'll notice that there's an accounts tab. Well, this accounts tab opens up to a menu of different features that you have available on your app itself. You'll notice here that you're able to update your profile, your account statements, you have access to them. You're able to basically instruct withdrawals, update your bank accounts. You're also able to see the terms and conditions that you have with your Sarwa account. Right middle of the page is where you'll see wealth beneficiaries. When you click on this tab, what you will see right away, and there you go, you're going to see the accounts that you hold with us. And in this example, this particular client has 2 accounts, and they've gone out of their way to name them as well. They've dubbed one the vacation account, and the other one, they've dubbed it for their child's education. Vacation, because they had an idea of traveling the world at a certain point in time. They wanted to save money towards it. Children's education is exactly as it sounds. They wanted to be able to subsidize their child's education needs. Well, we've made it so simple so that you're able to enter the details of your beneficiary so that if anything should happen to you, knock on wood, that there aren't going to be any barriers for your beneficiaries to receive these funds. Now, suppose you put child's education. In this section here, all that's required is you need to enter the legal name of your beneficiary. Highlight the percentage benefit that you would like to apply for this particular account. It could either be 100%. You want to ensure that this individual receives 100% of the proceeds from this particular account, or you may decide that you want to split the assets, maybe 50-50, 75-25, 90-10. It's up to your decision. Here you enter their name, their date of birth, their relationship to you. In addition to that, as an optional choice, is that you could also highlight their email address as well. And I'll highlight as to why that's important at a later stage in the presentation. In this example, we see John Doe and Sally Doe, children of our client, and they want to nominate a 50% beneficiary for John Doe and a 50% allocation towards Sally Doe, and they put all their details on here. As soon as you enter these details, you press continue, and here's where you'll be able to just confirm the information. You want to make sure that the details that you're entering are accurate, they're correct, and this is the page that you'll be able to see. If you're happy with what you see, you simply click the confirm button and voila. I think I said voila a little too early, but voila. This is the wealth beneficiary option on your Sarwa app. Now, why would someone nominate a beneficiary? I think that's a very important question to be able to, to address at this point in time. And I'm reminded of a situation that happened to me, several years back in my banking days, where a colleague of mine, relatively young, unfortunately suffered a stroke. middle of the day, middle of the working day for that matter. This colleague of mine, well loved by all of us, just a dear of a person, also had a wife and 2 children. The child was 5 years old, his daughter, and his son was just recently born. His wife was a homemaker. This colleague of mine was a fellow banker. And despite his knowledge of the importance of having a plan in place in the event of something like this should happen, unfortunately did not have anything in place. And what happened afterwards was a year of difficulties that his wife and his 2 children had to go through. It went to the point that we, as a group, as friends of his, were basically subsidizing the wife's day-to-day needs, even to the point of dropping off groceries for her for upwards of a year. Luckily, at the end of that year period, all things were resolved and she was able to access the assets that the husband had built for his family, whether it be real estate, whether it be the balances that were sitting in his bank account, whether it be the investments that he had, they were all there. And she was in need of them. She didn't have a means to be able to pay for the day-to-day things, and she required support. It was resolved eventually. But why I find this to be very important is because the turmoil that your family could go through if you do not address this in advance is quite considerable. And that's where a solution such as what we're offering through Sarwa, nominating a wealth beneficiary, or if something is a little bit more, if you have more complex needs, if you need something a little bit more holistic, that you're speaking to a solicitor, I do urge everyone in this, in this presentation today to have that conversation, as uncomfortable as it may be. But through Sarwa, you are able to nominate a beneficiary for your Sarwa Invest accounts. It's available through the app. Any individual can assign a beneficiary. And I know you're going to elaborate on this in a bit as far as what the differences are and whatnot, as far as different nationalities and religions and whatnot, Taslim. But from a Sarwa perspective, any Sarwa Invest account holder can assign a beneficiary. Beneficiaries can include a legal spouse, a child, parents, or siblings, natural, step, or adopted. Now, you could also, nominate beneficiaries that are unrelated to you, but they must be appropriately identified. And what I mean by that is you might have a great relationship, with the individual at the local convenience store. It doesn't really help if you just write in Jim from down the street. So be specific when you're nominating a beneficiary, please. If you'd like to assign someone below the age of majority in the UAE, so that's below the age of 21 years old, you are permitted to. But understand that there are limitations, and that is that the funds cannot go directly to that beneficiary if they're below the age of majority. I can't imagine giving a 15-year-old the entirety of your portfolio all at once. I think it's a little bit too much for them to handle. So what I want you to know is that in the event something does happen to you, that the funds will go to their legal guardian appointed by a valid court order. You can assign multiple beneficiaries, as you've seen in the video itself. You could also change the beneficiaries at any point in time. So it's something that you set up once and you'd like to adjust it or amend it, you can. You have that flexibility. You can also share the information with the beneficiary. And we've purposely created our app so that it becomes an option for you versus you mandating that you have to share with your beneficiaries. I can understand that maybe some discretion is required in these matters, that you may not necessarily want to inform your beneficiaries of the assets that you have. Well, what you'll have in this situation is the moment that you confirm it, you'll receive an email, a certificate that highlights what your wishes are. And you can very simply either forward that email or print it and put it in a safe place, or print it and give it to your beneficiaries at a time that you feel fit. In the event that something does happen to you, all that's required to be done is that your next of kin or your beneficiary needs to simply inform us, provide us with the legal documentation that highlights to us what's happened to you, and we will take care of the next steps without any bureaucracy, without any red tape. We are simply following your wishes. And that's what the benefit of this Sarwa beneficiary nomination is. I imagine there's probably a number of questions, and feel free to just put them into the Q&A, but I really want to jump into this part where it's my favorite, and I want to let Taslim speak about UAE inheritance laws. So at that point, I would like to bring it over to you, Taslim, and I want to maybe share some questions, some prepared questions that some clients have asked us in the past, if we can address them, that's all right.
Sure. Let's go.
Amazing. So let's start with, very beginning, more holistic, high level. who do the UAE inheritance laws apply to?
Okay, so obviously, if you live in the UAE, you're employed here, you have a residency visa here, and if you're employed here, you'll probably have a local bank account here. As minor as it may seem, if you have just even a local bank account and God forbid you passed away, then UAE inheritance laws will apply to you. So regardless of everything else, regardless of your nationality, etc., you come under the sort of the reach of UAE inheritance laws. So that's probably kind of obvious because you live here and you work here and you have an asset here. But I also get asked a lot of the time by individuals who are not necessarily resident here, but they have perhaps invested in real estate, for example. They've got an apartment which they've rented out. They're just, they're receiving the income. They've never actually come and lived here before. They've never got a residency visa, or perhaps they've invested in some funds here or some shares. And I get asked, well, I don't live there. I don't have a visa as such, and I'm obviously not employed there. Do UAE inheritance laws apply to me? Well, yes, they do as well, because again, it's not about you and where you're located, it's where the assets you own are located. So because you have invested in assets in the UAE, again, if you passed away, even if it was outside of the UAE that you died, UAE inheritance laws would apply to the distribution of the assets that are based here.
I understand. So it's irrespective of your residency, it's more or less where are the assets located?
Exactly.
Okay, so whether it be real estate or, and I notice in some cases, some assets, for example, even investment assets, let's just say you're investing in, DFM or any local, stock here within this region, that would be perceived as local assets in that case. Correct?
Exactly. Yes, because it's under the DFM. Exactly.
Okay. Now, it's UAE, many different nationalities, many different religions. When it comes to UAE inheritance laws, do they differ in their application to Muslims and non-Muslim individuals? Is the approach different?
Yeah, it absolutely is. So, I mean, we're all probably aware that the UAE is an Islamic country. And what that means is that a lot of the laws that govern personal status matters are derived from Sharia law, which is basically the Islamic law. And for Muslim individuals, the general position is that all personal status matters would be governed by Sharia law, or the codified version of Sharia law, which is called the personal status law. So, for example, if you have a Muslim couple and they are planning on getting married here, their marriage ceremony, their marriage process would be governed by Sharia law. Similarly, if you have a Muslim couple and they were looking to get divorced, then their divorce would be governed by Sharia law principles as well. And I guess in the context of what we're talking about today, if you have a Muslim individual who owns assets in the UAE, then yes, and if that person was to pass away, then Sharia law would determine the distribution of those assets in the event of death. And actually that applies regardless of the Muslim individual's nationality. So that's basically how it's dealt with for Muslim individuals. For non-Muslim individuals, as we said at the beginning, back in 2008, when I first came to Dubai, there was a lot of uncertainty. Uncertainty specifically relating to non-Muslim individuals and how their assets would be treated if they passed away. Would they be subject to Sharia law? Could they put a will in place, etc., etc.? There have been a lot of developments, and I would say since about 2015, there are now very clear, defined procedures and tools available for non-Muslim individuals who own assets in the UAE to actually put specific types of wills in place that would actually work and be effective for in respect of upholding their wishes for UAE-based assets. So there, not only one, we have sort of a few options available. So a non-Muslim can, for example, register a will through the DIFC, and that was introduced back in 2015. Prior to 2015, there was also an option to register a will through the Dubai courts, through the Dubai Notary Public Facility. That is still available as far as I'm aware. And then there is also now more and more options available through Abu Dhabi as well. So the Abu Dhabi Judicial Department has a non-Muslim wills office, allowing non-Muslims to register wills through that. And also the Abu Dhabi court has got newer initiatives to allow wills to be put in place. So as I said, a lot of development and a lot more options. And obviously, which option will suit which individual will really depend on their own circumstances and their own requirements, what assets they have, etc. One important thing to note, Eamon, is that if you are a non-Muslim individual and you do own assets in the UAE, if you don't actually have a will in place, or an effective will or a valid will, or a will that can cover your assets in the UAE, and you pass away, then it is very likely that Sharia law will apply to the distribution of those assets. So a lot of the sort of commentary and the sort of stories that you hear about inheritance in the UAE stem from those situations where you have individuals who have assets here, they've suddenly passed away, and Sharia law or a particular distribution has applied to their estate, which was perhaps not the one that was anticipated or the one that was wanted. Now, when we talk about Sharia law distribution for inheritance, I think it's important to illustrate what it actually means, because it's all very well and good saying that, Sharia law would apply to an asset. Well, what does it mean? How does it work? So I've got a little example, and if you can just pull up the slide for me. So basically, Sharia law for inheritance, the way that Sharia law applies to inheritance is it's a system of forced heirship. And forced heirship basically means that there is a system of rules that governs who inherits what when somebody passes away and in what shares. So that's all basically Sharia law inheritance is. The point to note, the principles of Sharia inheritance say that if someone passes away, two categories of people will inherit. One is those individuals that are related to the deceased by marriage, and the other category is those individuals that are related to the deceased by blood. So if we look at the example that's there on the slide, you've got sort of a fairly standard family situation. You have a husband, a wife, husband's mother and father are still alive, and let's say there's two children of the family, a son and a daughter. So if husband passed away and he had assets in the UAE and Sharia law applied to the distribution of those assets, if you can just go to the next slide for me, Eamon, you'll see what the distribution is. So the estate would actually be carved up in the shares that you see on the slide. So you'll see that as long as the wife survives the husband, she will inherit 1/8 of his estate. Again, as long as each parent survives the husband, they will inherit 1/6 each. And the remainder will go to the children, with the son inheriting double the share of the children. Double the share of the daughter. Okay, so that's just an example of the division based on that family structure. And obviously, the actual structure that will, the actual division that will take place will depend on which individuals survive the deceased at that time. Now, when I go through that example with clients, there's usually a little bit of, put it mildly, surprise from the side of the wife to see that, well, I'm only going to get 1/8. So usually the conversation goes something along the lines of, well, how about we put everything in the wife's name? Because the general assumption, excuse me, is that if wife passes away under Sharia law, husband will get everything. It's a misconception. It's absolutely not how it happens. And if you can just go to the next slide for me, Eamon. If we flip the example and assume same family structure, but this time wife passes away, leaves again a husband, her parents, and a son and daughter, you'll see from the next slide that the division is actually very similar to when husband died. So actually the only difference in the share is with the surviving spouse. So if it's wife that dies, husband inherits 1/4, and if it's husband that dies, wife inherits 1/8, which is half. The rest of the shares remain exactly the same, but of course in this slide you'll see that it's the wife's mother and the wife's father that actually inherit the 6, but the son and daughter inherit the same. Okay, so that's that's an example of the inheritance under Sharia law. Now, as I said, if nothing is done at all, it's likely that the division will follow those shares. But of course, the ultimate division will depend on what family members survived the deceased at that time. So it's important not to take this as, this is in concrete. It will depend on how many children there are, their gender, and the family and the parents that are remaining after death.
Is this by and large, is this what's followed more often than not? Or is there a level of subjectivity here as well?
So in terms of the shares, there are general shares that are always applied and general proportions that each individual will always inherit. Subjectivity only comes in if there is a will and it's a valid will, and also the distinction, or I suppose the differentiation of the shares will be impacted if one of the family members who is an heir decides to give up their share formally. So that's also permitted under the division, but only after the date of death. So somebody, for example, cannot say, well, if my son passed away, I don't want to inherit anything, I'll let my daughter-in-law have it all. That can only be declared after the death of the individual.
Okay, I understand. Now it's funny that, the next question that's been posed relate to this as well. And maybe I just expand on it, just to add a couple of, context to it. So do expats need to do anything in order to deal with UAE inheritance considerations? And I think it's fair to say UAE expats, whether it be Muslims or non-Muslims, I guess, what are the considerations that they need to take into factor in when it comes to UAE inheritance laws?
Yeah. So I guess the way to sort of answer that, where I would start, is to look at the situation, look at the factors that would actually not be dealt with if there was no planning done at all. So if a will wasn't put in place, if you can just go to the next slide for me, Amy, please. Now, when you have assets or you acquire assets or investments, and whatever nature they be, you may at some point in time think, if I'm no longer around, I would hope that, my parents are looked after, or I would hope that, my wife gets gets the family home, or et cetera, et cetera. You probably had a thought about what you would want to happen. And unless you put those thoughts in a legally recognized format and execute that document in the appropriate manner, that's not going to happen. So there is no statement of your intention. And if you don't have a valid and legal statement of your intention, it cannot take place in respect of your assets. Similarly, if you've got quite a complicated estate, so you've got investments all around the world, you've invested in startups, and you've invested in, for example, cryptocurrency, etc., and you don't really think that perhaps your spouse or your parents or your children are going to be suitable or perhaps capable, or even want to deal with all that when you're no longer around. Unless you've actually put a will in place, you can't name what are called executors. And the role of the executors is just that. It's to unravel your assets, to make sure they're administered in the right way, and then eventually to make sure that they are distributed in accordance with your wishes that are stated in the will. Similarly, you may feel strongly about, how your funeral is conducted. You may absolutely not want to be cremated, or you may absolutely not want to be buried. And typically, if you've put a will in place, that is the document in which you would put down those personal wishes and those personal declarations. So without a will governing all that information, who's going to know, and how's it going to be upheld? I guess most important for me, and most important in the context of what we're speaking about today, is that if you don't have a will, but you have, for example, assets in a particular jurisdiction and they are assets of value, something or someone has to decide what happens to them when you're no longer around. And typically every country, every legal jurisdiction will have a set of default laws that will determine what happens to a person's assets if they pass away without leaving a will themselves. And they're usually called intestacy laws. So as I mentioned earlier, in the UAE, we have a system of forced heirship, which is basically based on the Sharia laws. In other countries, there are similar rules. So for example, in England, we have what are called the intestacy laws, and they prescribe quite in some detail which family member gets what share of an estate. And the only way to override them is by putting a valid will in place. Another important factor, which we're seeing a lot of, as time goes by, is that family structures are changing. It's not usually the typical husband, wife, 2 kids, etc. There are blended families. There are families that are, growing in different ways. There are stepchildren involved. There are adopted children involved. There are couples who have lived together for many years and aren't actually legally married. And it's worth noting that a lot of the default inheritance laws of most countries don't actually take into consideration the rights of those individuals in relation to the person who's passed away. So, for example, in a lot of jurisdictions, stepchildren would not receive a share of an estate by default, as wouldn't adopted children. Perhaps unmarried partners would also not receive a share of the estate. So what would then, the situation that then arises is that you have people who you have lived with your entire life and you've supported and you've lived with as your own family, but because you haven't put a will in place or you've not declared legally that you want them to actually benefit from your assets when you're no longer around, the law steps in and determines what happens. Those individuals are left without, and typically they would be advised to make a formal legal claim against your estate. And obviously that means going to court, getting lawyers involved. And Eamon, when courts and lawyers get involved, it just means a lot of time and a lot of money is wasted in trying to reach a resolution, which could have all been avoided if a will document had been put in place. So really, the consequences, coming back to your question of not doing anything, and this is not obviously just specific to the UAE, this is really, it applies anywhere. So if you have assets anywhere in the world and you have not put a declaration or a will in place which says what should happen to those assets in the event of your death, these are just some of the factors that would not be addressed and could have quite serious consequences.
No, very loud and clear. I mean, that was actually the inspiration as to why we're working on this wealth beneficiary for quite some time, because you're not, with us to be able to dictate what your wishes are. And we would have to rely on the courts to tell us what to do with your assets. Assuming that something had happened to you, we don't have the right as your relationship managers or asset managers to dictate who your assets will go to. And we would rely on the courts providing us a succession certificates to instruct us as to how to bequeath your assets. Well, nominating a beneficiary gives you a little bit more control. That's the benefit of having this service altogether. But you touched on something, Tasneem, which is really key. Children, and especially with regards to guardianship. Well, what does that look like, in the event that something does happen to us and we have children here in the region?
Sure, yeah. So just before we talk about assets for a moment, talk about guardianship, I just want to step back a little to talk about assets. And I think it's important in the context, especially of the UAE and in the context of expats, what actually is an asset. So we've mentioned it a lot. And we've sort of, thrown in the odd sort of bank account example, real estate example. But if you can just go to the next slide for me for a moment. Assets in the context of an inheritance situation are broadly split into 2 categories. So you have immovable assets, which basically are real estate or anything connected to the land. So it could be a property, a villa, an apartment, it could be commercial property, a garage, a parking space, whatever it is, that's regarded as an immovable asset. And generally, every legal jurisdiction or every country in the world will have a law that talks about how an immovable asset located in that country can be dealt with in the event of death. So that the law may say that you have to put a will in place, or the law may say that you cannot put a will in place and we will determine how it's dealt with in the event of your death. So that is something important for everybody to note, that how is real estate dealt with in that particular country. And I say that because in the UAE, we come across a lot of clients who've got, real estate dotted around different jurisdictions. And often it's not the first thing that comes to mind when you're buying that holiday home in Thailand. Well, what would happen to that property if I passed away? Do I need to make a Thai will, for example? And usually the answer is going to be yes. You need to get that additional information, go that one step further. When you signed on the dotted line and bought your holiday home, just check what happens if I died, what laws are going to determine how that property passes. With regard to the other category of assets, movable assets, that basically covers everything else. So in the UAE, as a typical expat will probably have at least a bank account, a local bank account that they've had to open because they're going to be paid their salary in that local bank account in local currency. That is an asset for the purposes of inheritance. So if they then passed away and they had nothing else at all in the UAE, they would still need to have an inheritance file open, because it's actually the inheritance law that determines what happens to that bank account that's located in the local bank. Similarly, another asset that's very often overlooked in an expat context is an end of service gratuity. So as employees here, most of us will be on a local labor contract, which under local labor laws, we are all entitled to accrue an end of service gratuity. I come across clients who've been with the same company for 10, 15, 20 years. They're accruing that gratuity, which typically is calculated as about a month's salary for every year that you've worked after you've completed 5 years of service. So those who've been with a company for sort of 10, 15, 20 years, it's going to be a sizable sum. And it's usually those same individuals who say, well, I've kept nothing in the UAE, I don't have any real estate, I lease my car, I don't own it, etc. If they were to pass away, the end of service gratuity is actually an asset, and it's an asset that belongs to their estate, which would then have to be dealt with under the laws of the UAE. So it's worth having an awareness of what actually constitutes assets and real assets for inheritance purposes, specifically for expats. And again, it's also things like your motorbike, or you've got a boat. And all of these assets, if they're registered with a government department in the UAE, in the event of death, an inheritance file will have to be opened for that individual to determine who actually inherits them as a result of the death.
Okay, amazing. And I see here also company shares, life insurance. What's DIS? And I know EOS.
EOS is end of service payments. Actually, that's a good point that you picked up on. So company shares, absolutely. If you've got a local company here, whether it be shares in an LLC or a free zone company or any type of a company in the UAE, if you are a shareholder, that would also have to go through the same process to determine who inherits those shares in the event of your death. With regard to life insurance, similar to how we've got the Sarwa Wealth Nomination Form, a lot of life insurance policies have that option as well. So it's worth checking with either your financial advisor or your life insurance provider if there is the option to fill in a nomination form, because if you have filled in a nomination form and you pass away, the life insurance company will probably uphold the wishes in your nomination form. And it just means a smooth transition to make sure the payout from the insurance goes directly and quickly to your named beneficiary. So again, it's an advantage to look into that as well. Death in service payments typically tend to be offered by some larger companies as an employee perk, as it were, and they too will probably ask you to fill in a nomination form, which if you passed away while still in employment, that death in service policy will kick in, and the nomination form can be upheld by the employer. So it's just worth having an awareness and making sure that you've checked whatever you own, you do know what would happen and how it would be dealt with if the worst was to happen.
Understood. I think a good example of that would be that employee savings plans or employee share plans or share match plans, any number of different programs that we can see within the region. Never thought to think about making sure that you nominate a beneficiary, because that is an asset that you have that many of us tend to forget about as well too. It's a good point.
Yeah, exactly. And now in the DIFC, for example, you have the dues scheme. So if you're a DIFC employee, you're not accruing, I think it was from a couple of years ago, you're not accruing the normal end of service gratuity under labour law, but you can actually switch to following into the dues scheme. And that actually should also have a sort of a nomination form option, which people are encouraged to fill in, because then that can determine who gets their end of service in a much quicker and more efficient way.
Understood. Loud and clear. Thank you for that. I want to touch back on the guardianship question. I think that's a question that's come up quite often, but I'm also conscious of time because I know there's a number of other questions that we have to address, and there's a number of questions in the Q&A. But maybe just a quick overview as far as what about guardianship for children in UAE? How does inheritance laws apply there?
Yeah. So sure. So with regard to guardianships, as Eamon said at the beginning, a minor under UAE law is anyone under the age of 21. So what follows is that if you have children and you pass away, who's going to look after those children? So again, local Sharia law does have a sort of a statement as to how guardianship should pass in that situation. So if parents passed away, who would be the guardian? And it's typically the next male heir who survives the deceased father. If you're a non-Muslim individual and you have children here, one of the other very important reasons to put a will in place is for you to be able to name and nominate your own guardians. And specifically from a UAE perspective, because most of us are here without our close family also residing here, I usually advise that you name not only permanent guardians, but temporary guardians as well. Sorry, Eamon, if you can just switch to the next slide for me. Yeah, so the slide just shows two types of guardians. Testamentary guardians are typically those individuals that if you've got a will in your home country and you've got minor children, you will have named guardians in the will, and they're referred to as testamentary guardians. So they're the individuals who will step into your shoes as parents and look after the children until they're adults. Temporary guardians are more of a specific UAE specific concept, but it's there for those individuals that, they have very close friends here, they've got neighbors who they trust or whoever, work colleagues. And if both mum and dad passed away in an accident and the kids are at school, who's going to look after the kids immediately? And that would typically be the temporary guardians. Not only care of the children is dealt with by the guardians, but also from a sort of an asset context. If both mum and dad passed away, and it was the children who then inherited the assets, it would actually be the guardians who would manage the assets on behalf of the children until they became adults. So a lot of thought should go into appointing guardians when you've got minor children.
The more we delve into this, the more complex it becomes, as we realize.
Yeah, there's a lot to think about.
A lot to think about. Speaking of complexities, as expats, many of us may also have assets offshore. Maybe in our home countries, we may have real estate, we may have bank accounts, we may have investments that are running as well. Some of us have already taken the step of creating a will, but it's not here in the UAE. How does that all factor in?
Yeah, so first thing I would say is that assets in multiple jurisdictions is a complex situation. So you really need to look at everything separately, but also together. And one of the things that I would say is that first inspect your assets from a location perspective. Where are they based? And then a type perspective. So what type of assets do I have? And generally, as I said, two types of assets, movable and immovable. If you've put a will in place, for example, in Canada, Eamon, and it's for your real estate that you have there, and you think, well, I've now bought some real estate here in the UAE and I've got a couple of bank accounts, surely I can just use my Canadian will. Well, the answer to that is, short answer to that, should I say, is probably not. Slightly lengthier answer is that you may be able to use your Canadian will for your movable assets based in the UAE, but probably not for your real estate here. And that goes back to what I was saying earlier, that most countries have laws that determine how real estate should pass in the event of someone's death based on the laws of that own country. So there's a sort of a concept of conflict of laws, and it's very it's complicated, so advice must be taken, but generally you will not be able to use a foreign will for local real estate.
Okay, understood. What other considerations should we take into, should we factor in when it comes
So based on the sort of, multinational, if you've got a multinational portfolio, tax, we're very lucky in the UAE. We don't have anywhere near the level of taxation that exists in a lot of other countries in terms of sort of personal income taxation, etc. We also don't have what are called inheritance taxes here in the UAE, but I'd say most other countries do. And what that means is that you may be faced with a situation if you own assets in the UAE and you own assets in other countries, your home country, depending on what your domicile is, may assess an inheritance tax bill based on everything you own in any part of the world. So you're going to be faced, or your estate is going to be faced with quite a huge bill. So again, it comes back to taking that advice. If you find yourself in a situation where you've got a lot of assets in a lot of different jurisdictions, there are ways that there are structures and different types of arrangements that can be entered into to make sure it's all been owned by you in the most tax efficient manner, so that not only if you pass away, your estate or your family are not paying the level of taxes that you may otherwise be subject to, but also that your assets are being divided and distributed in a more controlled manner. So you can look into things like trusts, you can look into things like foundations. And now in the UAE, we're incredibly lucky because these concepts and these structures are available in many of the local jurisdictions. So we have DIFC foundations and DIFC trusts, we have ADGM, we have the RAC ICC. So there is a recognition and there are solutions that are available to empower people to make sure that whatever wealth they have acquired is going to be dealt with in the most efficient way and with the most control that can be given.
Oh, understood. I mean, these are great discussions we're having, to stay honest. It's pretty amazing. And I know, with every topic that we address, it's probably 10 more questions on the back of this. And I could see our Q&A section, ringing like a phone at this point in time. So I would love to jump into the questions that our audience members are asking. There was one where, it was asked quite often in the Q&A as we were, having this presentation, which is, okay, fine, fair. It's important to have this discussion. But what practical steps can I take now to make it easier for my executor? Whether I do have a will or whether I do not have a will, whether I assign a beneficiary through Sarwa, whether I do not, whether I do it through my insurance company, whatever it might be, what steps can I take now to just make that easier?
Okay, so I think, and I know it will sound really, really obvious and perhaps a little bit silly, but the number of clients that I come across, and I ask the question, right, how many properties do you have? Where are your bank accounts based? And they'll be like, do I have 2 properties? Did I sell one? And it's like, really, you don't know? So that would probably be my first tip, is that think about what you own, have an awareness of what you own, and then document it. Put it in a simple spreadsheet. What is the asset, where it's located? Is it financed? Is there a life insurance policy? What's the account number? And you don't have to share that with anyone, but it's a good starting point just to sort of gather your assets, because once you've got all that information in one place, you can then start looking a little bit deeper. How do I want that to pass if I passed away? Do I want to keep that? Do I want to perhaps put that in an alternative structure? Is that going to attract tax? Which country is going to, which country's laws are going to apply? So it's a sort of a very basic review of what you own. And then I guess sort of building on that, if you have a family, perhaps you're married or you've got children or parents, etc. A lot of the inheritance cases I deal with, have an element of the unknown. So a family member will come to me and say, so-and-so has just passed away. I think there were bank accounts here. I think there was a property there. Well, realistically, how is your family going to know? If you haven't put something in place just to sort of list or document your assets, you're sending your family on, a kind of a huge, either a wild goose chase or a detective exercise to kind of track down what was actually owned just based on, some files or some documents or some correspondence or, an email inbox. So it's just about being organized, I'd say, as a starting point.
Do you have any recommendations as far as like a safe place to put these documents or, this information, or maybe examples of something that your clients have done in the past?
Yeah, so a lot of people these days have either private accountants, or they have financial advisors, or they have lawyers. And that's probably where you're starting to have these conversations. So if, for example, you're doing a will, and you're doing it through a law firm. The lawyer will typically be able to offer you the facility of storing the original will, so that's a safe place. They may have a strong room. If you're registering it through the DIFC, it's usually stored electronically, but they would still have the facility of keeping a copy of those documents. And I always say to clients that, if you want to, you can put a list of your assets together, and we can keep it with a copy of the will, so that, God forbid, if anything happened, at least there's a starting point. And then, of course, the onus is on the client to make sure that those schedules, those lists, etc., are updated on a fairly regular basis, and that the people that or the companies or whoever have been shared with, they are updated as well. Some clients are not too comfortable sharing those things with their family, and that's absolutely fine. They use things like bank safe deposit boxes, they use, safes, etc. Really, the best solution is the one that you're comfortable with and that will work in your circumstances.
Lovely, thank you. There's a number of questions related to the wealth beneficiary nomination on the app itself, with regards to which product is it available on and which one is it not. So Sarwa Invest basically allows you to nominate a beneficiary, and you can nominate beneficiaries for any one of the accounts that you hold through Sarwa Invest. Sarwa Classic, which is basically a partnership between us and Interactive Brokers, does not permit you to nominate a beneficiary. Sarwa Trade at this point in time also does not allow you to nominate a beneficiary. However, we are in discussions to see if we can make this a reality. Similar to the steps and the process and the journey that we went through to make this a reality for Sarwa Invest. We're having the same conversations with our partners for Sarwa Trade. So please do stay tuned. The moment that this does become a reality, we will make sure to inform everyone, and we'll be happy to be able to provide this service should this be possible. There's a question here that says, what exactly happens if a person passes away without specifying a wealth beneficiary? I addressed this in the past, previously, but I'll just touch upon it again. If you do not nominate a beneficiary, there isn't anyone here to be able to speak on your behalf. You're no longer with us. So we have to rely on the courts of your where your assets, or sorry, where you reside, in order to be able to provide us I would say direction on how to allocate or how to bequeath these assets. And from the UAE context, it would be that you would proceed to the courts, obtain a succession certificate, and then provide that succession certificate over to us, to which that we would follow to the letter of the law itself. There's a question here. Can Muslims appoint beneficiaries on Sarwa Invest? Yes. Any individual, any nationality, any religion can nominate a beneficiary. Okay. There's a question here from Matthew. It says, if we assign beneficiaries in a registered expat will in Abu Dhabi, could this be used to bequeath my Sarwa assets without assigning a beneficiary in the Sarwa app? Or is signing in the app essential? That's a really great question, Matthew. So the ultimate solution would be to have a discussion with a solicitor and put, basically your wishes on paper, because your financial picture is probably a lot more complicated. And as we've discovered in this conversation, a lot more complicated than just your Sarwa investment. We take into consideration your movable assets and immovable assets. That is the ideal solution. But for those who don't have the capacity to be able to create a will, may not have the financial means to create a will, or maybe just haven't had the time to create a will, this becomes a real ideal solution for you through Sarwa, for your Sarwa Invest, assets that you have. I would still recommend that, do speak to a solicitor, and it looks like in this case you have, Matthew, which is a really great thing to do. But for those who are looking for a quick solution that is, be able to execute it rather quickly, Sarwa Invest might be an ideal solution for you. Let's see here. Can a will, and this one probably maybe you can assist us with this one, Taslim, can a will supersede Sharia law for Muslim individuals? And I think maybe we can take a step back on this. Can a Muslim individual create a will? I think maybe it's a two-part question we could address.
Yeah, so good question. If we're talking from obviously a UAE context, then as a Muslim individual, yes, a Muslim can put a will in place, but it would not be the same type of will that a non-Muslim individual can put in place. So for example, a Muslim cannot register a will through the DIFC or through the Abu Dhabi Judicial Department, because those options are available specifically only for non-Muslims. However, under Sharia law, there is the facility for a Muslim individual to put a will in place, and it's called a wasiya. But typically, the wasiya can only cover up to 1/3 of a Muslim individual's estate. The other 2/3 would have to go in accordance with those fixed shares that we went through at the beginning. And the purpose of the wasiya is not to leave, for example, if you've got a husband, it's not to leave everything to the wife in the wasiya, it's to leave assets to somebody who is not actually a default Sharia heir. So if, for example, you want to leave to your best friend or your neighbor or a charity that you've been supporting throughout your life, you would do that as a Muslim through a wasiya. So it is possible to put a will in place for a Muslim, to summarize, but it's not going to be the same type of will that a non-Muslim would be able to make. And it's very difficult, probably impossible, to override the default Sharia distribution in a will. In some circumstances, it may be possible, but it's complicated. It depends on the family structure at the time of death.
Okay, lovely. There's a great question here by Jean-Paul. He says, what does the person named as a beneficiary in the application need to provide as documentation in the case of death for the assets owned, through Sarwa? And to answer this question, Jean-Paul, in this case would be a death certificate. Your beneficiary would need to provide ID, and lastly, proof of address document. These are the 3 key documents that we're looking for in order for us to be able to execute based on your wishes. Now, therefore, I'm conscious of the time because we're over the 7 o'clock, time limit itself. Are you okay to stick around for a few more minutes, Tasneem, so we can answer a few more questions?
Sure,
okay.
Sure.
And for the audience members, if you're not able to stay, no worries. This conversation is recorded, and we will be sharing it via email to you. So if you have to log out at this point in time, completely understandable. And I just wanted to mention that we have an FAQ page on our website. If you go to this image over here and take a picture of it, it'll guide you directly to our website where the FAQ page, where a number of these questions are being addressed or have been addressed on there. There's a question here with regards to what is the process of registering a will, which we already covered it already, but the question more specific is, can it be done by an individual, or do you require legal counsel to be able to put a will in place?
Yeah, so the answer to that will depend on where you are looking to register the will, the type of will that you are looking to register, and are you going to be drafting the will yourself? Who are you going to be appointing? If we take the example of, for example, the DIFC, so a non-Muslim can register a will through the DIFC, and it's really a 2-part process. First, you need to have the will drafted, and that typically, I'd say, is the stage where it's important to get legal advice to make sure the will is drafted to reflect your financial circumstances and your family situation. Once the will is drafted, it then needs to be registered at the DIFC. And what that basically means is that the person who's making the will has to sign it in the presence of 2 witnesses. Now, the DIFC is developed incredibly well post-COVID to allow the whole registration process to be conducted virtually. So you don't need to attend in person at the DIFC or at any of the offices. You would just basically have a Zoom call or a Skype call. The registrar would be present. You'd have your 2 witnesses there, and you would sign the will electronically, and it would then be encrypted and saved on your behalf. So you only need a lawyer to help you with the drafting of the will, and the registration side, not necessarily would you need a lawyer to assist you, but you'd need to obviously know how to register and what documents, etc., would need to be submitted.
Amazing. Thank you for that, Tasneem. There's a question here. It says that states, if we invest in US-based ETFs through Sarwa, which inheritance laws would apply? And this is a really great one. And I'll get into a fair bit of detail here. And for some, might call it, understanding how the hot dog is made in itself. But keep in mind, although these assets are purchased through US domiciled exchanges, as far as the domicility of these assets, they're offshore in the example of Sarwa Invest in Denmark. And the reason why it's in Denmark is because the back end of Sarwa Invest, we've partnered with Saxo Bank, and Saxo Bank is domiciled in Denmark. So it's an offshore, domicility, which means it's not subject to UAE Sharia law. And it's not also subject to US laws as well, because the domicility of these assets are basically held offshore via Denmark. I don't know if there's anything else you would like to add on Denmark, Taslim, because I know we've done quite a bit of work here, but by a very simple approach, it's not exposed to US estate laws when it comes to Sarwa Invest.
Yeah, and I think Eamon, you explained it very well, and I think that the bottom line is it's where's the underlying asset based, and that would be the law that governs succession of that asset. So it doesn't matter where you sort of enter into the contract to acquire that investment, or the sort of broker is located, etc. It's where the underlying investment is, and that would then determine which inheritance laws apply to it.
Mm-hmm. There's a couple of questions. Again, we're going back to the will aspect of things, right? So a gentleman asked, he said, so what you're saying is that all expats should make an inheritance will through the DIFC? So they're being very specific to say DIFC versus other options here that we've discussed earlier.
No, I'm absolutely not saying every expat should make it through the DIFC, but the reason I mention DIFC frequently is because it's probably the first registration process available specifically for non-Muslim individuals that I have personally experienced to work effectively. And what I mean by that is that I've assisted hundreds of clients to register wills through the DIFC. Unfortunately, I've also experienced I'd say a handful of those clients who have subsequently passed away. And I've then been instructed to assist the family to uphold the will in terms of the application of the contents of that will to the UAE-based assets. And what I can report back is that the will was, it did exactly what it was supposed to do in a very efficient manner. It was a straightforward process. And that's the whole point of doing it, because otherwise, the family would have had to go through a much more involved and expensive process. So that's why I mentioned DIFC, but that's not to say that, the DIFC is going to be suitable for everyone. There are other options available. As I said, there's wills that we've registered through the Abu Dhabi courts. There's wills that we've registered through the notary public. I'd say that in terms of sort of speed and efficiency and user friendliness, DIFC is certainly, the most advisable option. But again, it depends on the individual and the assets that they own and what their requirements are.
Excellent. There's a couple of questions with regards to fees. One with respects to the Sarwa nomination, but also with regards to fees when it comes to wills. So the first question is, if we have multiple Sarwa accounts, is the fee $49.99 for each and every one of the accounts, or is it a flat fee for all the accounts consolidated? The answer to that is it's a flat fee for all of your accounts, meaning not on an individual basis. So you could have multiple accounts, or you can have one account, you pay a flat fee for the service altogether. And that fee basically allows you to amend, nominate as many individuals as you'd like. You can adjust it from time to time. So it's a flat fee, one-time fee that you're paying basically for all of the accounts that you hold with Sarwa. And the second question with regards to wills, there's a number of questions that are asking about the range of what to expect from a fee perspective if you decide to have a conversation with a solicitor about putting in place a will. Do you have a range that maybe you could look at? Or, I know it's quite complicated because everybody's assets are very unique and there's multiple different considerations, but what would be a typical expense, I guess, when you're looking at a will?
So with the sort of fees for wills, there are, again, two elements. There's the registration fee, which would be payable directly to the entity where you're deciding to register. So, for example, again, to use the DIFC, if you decide to register the will at the DIFC, there is a fee payable directly to the DIFC. That will typically start at around 10,000 dirhams for a single will, if it's a full will that you're going to be dealing with your assets and guardianship. But the DIFC does have options for clients, for example, who don't have any assets here, but they're just worried about guardianship. So you can then put in place what's called a guardianship only will, and the registration fee for that is lower. I think it's around 5,000 dirhams. But sort of registration fees aside, there are, of course, the legal fees. So legal fees for wills, it's difficult to give a figure because, as you said, Eamon, it depends on the client's requirements and their assets, etc. But we try and do it on a fixed fee as much as possible, so you know at the outset how much it's going to cost, and we make that assessment, after we've had a conversation with you. So we will go through your information. We'll have a chat with you. We'll give you, the options that we think are suitable, and then accordingly we can work out a fee for you.
Lovely. There's a great question here that asks, if a person has nominated a beneficiary through the Sarwa wealth beneficiary platform on the app, but they also have a will in place, are there conflicts that could occur between the two? Which nomination would take precedence? Now, let's take a step by step as to what would happen. In the event that we are notified of your passing, and let's take the example where your beneficiary approaches us and provides us the information that you've passed away, we have the information already on file that states that your wishes are for us to bequeath these assets to that individual. Once to provide the necessary documentation, as we just highlighted earlier, such as death certificate, ID, proof of residence, or proof of address, wherever they may reside, that is exactly what we would be executing. And we would do that quite hastily. And what we would do step by step is, first we would freeze the accounts because of the notification. And while we're waiting for the paperwork, and once we receive it, we would process it accordingly by liquidating the portfolio and basically transferring it to the account of the beneficiary themselves. If we are notified that this individual has passed away, but we are notified by way of a succession certificate, we will follow the succession certificate. So really, at this case, it comes down to is what documents are we receiving and who is notifying us at that point in time. If we get notification by the beneficiary themselves and they approach us, we will execute accordingly. If we receive a succession certificate from the court of law, we will follow that rule. Maybe we'll just take a couple more, and then I think we'll call it a night at that point. What I'll do is I'll take Sandeep's question. It says, what happens in the case of joint accounts and the partner survives? What happens is the Sarwa accounts that you hold, if it's a joint account, there's an automatic right of survivorship. So if anything should happen to you as an individual, automatically the assets would be transferred over to the surviving account holder at that point in time. So husband and wife, something happens to the husband, the wife would automatically basically receive the assets, because that is by virtue of the jurisdiction that your assets are lying in. And this is for that reason why at this point in time, you're only able to nominate a beneficiary for individual accounts, because joint accounts already have that safety provision in there. Maybe one last question. Okay, let's talk about assets once more. In order to, when you create a will, let's just say once you create a will and you acquire more assets after you've written the will, am I required to amend that asset? Maybe take it a step further. If you've identified that you have a certain balance in your bank account, and that balance grows after you've written out your will, does that mean that you're required to update it?
Generally, no. So the way that I tend to draft wills for clients is to keep them general in terms of assets. So unless the client wants to specifically leave an asset to a chosen beneficiary, so my house, my apartment in the marina to my brother, I will refer to the estate as a whole. And the advantage of that is that whatever assets are owned by the individual as at the date of death, the will is going to cover. So there is no need to keep updating the will when you acquire more assets or when you sell assets. The only time you really need to update the will is if any of your beneficiaries change, or your executors change, or you do decide that you want to leave a specific asset to a specific individual.
Amazing.
So it all comes down to the drafting, basically, of the will.
Very good. So I guess what I understand what you're saying is if you're too specific, then that might require you to update your will. Whereas if you take a little bit more of a general approach, it's probably the best approach to take in that regards.
Yeah, exactly. Yes.
Good. Well, thank you so much, Taslim. Today has been an amazing conversation. It's been very eye-opening. And to the audience members who are still with us at this point in time, Taslim's contact details are shared with you in the chat section or in the Q&A section. So feel free to reach out to her if you're looking for advice and guidance on how to plan your estate. And with regards to Sarwa, the wealth nomination application is up and running. So feel free to log into your app on your phone and nominate a beneficiary. If you have any questions, feel free to reach out to us. We'll be more than happy to clarify on how to add a nominee. But otherwise, thank you so much. It has been a pleasure, and thank you for joining us today. And Taslim, pleasure again.
Thank you so much, Eamon. It's been great. Thank you for having me.
Excellent. Have a wonderful night, everyone.
Have a good evening. Bye-bye.